We have issues that kind of relate to the standards of fair trial in relation to also Ukraine's obligation under the European Convention on Human Rights. And this is something that is a very real sort of threat to Ukraine as well.
Medieval crimes are being committed.
I come with clean hands.
Victims of horrific crimes want justice.
We don't have anything better than this.
This is Asymmetrical Haircuts, your international justice podcast, with Janet Anderson and Stephanie van den Berg.
All rise.
Hi, Steph.
Hi, Janet.
Welcome to another episode in our mini-series focusing on Ukraine. So far, we've been looking at prosecuting conflict-related sexual violence and possibilities of prosecuting hate speech. And we're going to be covering some more general issues about gender. And after the summer, we're going to be looking back at the registry of damages.
But now we'll take a look at what's going on with Ukraine's domestic legal system, which had the unenviable and never really before seen task of prosecuting war crimes allegations during an ongoing conflict.
So to help us get an idea of what's actually going on in the courts and on the ground, maybe with some investigations too, we have Nadia Volkova, the founder and director of ULAG, that's the Ukrainian Legal Advisory Group, which is an NGO that works on justice and accountability in the context of armed conflict. Hi, Nadia.
Hi, Janet. Hi, Steph.
Nadia's been on our pod before in 2022 when the ICC prosecutor just opened an investigation into Ukraine in our Ways on Accountability episode. And we thought we'd give her a solo gig to talk to us about ULAG's recent need assessment report on Ukraine's justice system. And from the executive summary, I wanted to quote a bit. It says, "The occupation and the subsequent full-scale invasion of Ukraine by Russia has put to test the effectiveness and the efficiency of the existing architecture of justice that the world can offer. 10 years of the ongoing armed conflict in the territory of Ukraine and 2 years of invasion have revealed that even the most robust justice-related response, consisting of engagement of the existing accountability options and complementing them with specifically created and tailored mechanism, has not proven to be effective."
Whoa, I think that's legal speak for, oh my God, it's not going very well. Later on, also, I will say we're also going to talk to you about what kind of international accountability mechanism might be set up. But let's turn to that assessment first. What do you really want to say, Nadia?
Well, the idea for the report was that we actually put together in one place, in one sort of document, all the challenges that have been revealed so far, because there was an idea that this such a robust and such an active justice-related response that Ukraine received was an ideal sort of way forward to make sure that there is no impunity for everything that's going on in Ukraine. However, as it turned out, and we've been sort of following the situation with the investigations and the prosecutions and adjudication of conflict-related crimes or international crimes in Ukraine and by other mechanisms such as the ICC, that in reality there are many challenges still. There are many gaps that need to be revised, that need to be analyzed, and that need to be closed, essentially, for the justice architecture to work in concert against the different elements of the justice architecture. And for some mechanisms, even they need to be reevaluated and redesigned, I would say.
That's all very general. If we kind of focus down to specifics, every time we speak to the Ukraine Office of the Prosecutor General, they're hard at work. They're listing the number of investigations they're doing. They're investigating lots and lots of allegations. But how are they actually doing in this field? Do they have the tools to deal with the amount of allegations that are coming their way? And do they have to do each one separately, or can they do broad thematic investigations? How do you see that going?
This is true that they're hard at work, and we have been trying to monitor and also help them out officially and informally in their investigations as much as we can by being legal representatives or lawyers in some of the cases and sort of guiding them towards the use of the international standards and certain procedural aspects of the investigations. For example, the use of evidence that they can rely on, or who they can go and interview, and how this interview should be conducted, to what standard, whether it's worth re-interviewing victims over and over again, or it's actually enough to interview once and then use that interview for the actions that they need to undertake. But generally speaking, I think there is no legislative background that would allow them to actually work effectively, because Ukrainian legislation, the way that it's drafted, it was geared more towards sort of peace times, even though we have some of the international crimes sort of definitions, but they kind of like the Ukrainian version of those definitions. Like, for example, with a crime of aggression is a very sort of, it has the almost like opposite sense of what this definition is in the Rome Statute, especially in the terms who the perpetrators can be.
So what you said about the Office of the Prosecutor General and the way you help them, it also sounds like they're still very much at the beginning of this journey in learning how to deal with these kind of allegations. But you also already touched a bit on the legislation that's in place in Ukraine. Is the domestic legislation up to par? You explained that you have some international crimes, but they are like the Ukrainian version. What about things like in absentia trials? We hear a lot about them. Ukraine has them. You know, how is that going? How do you think that's going, and how could that improve?
Yes, in absentia is one of the sort of key problems right now. But there are many. In fact, if we're talking about substantive law, for instance, is not as much of an issue in Ukrainian legislation as procedural law. And we're talking about Criminal Procedure Code of Ukraine, and in absentia is part of that procedure. So it's not really what the OPG sort of the aware of the problem. We've had them, or problems, we've had them throughout the entire duration of the armed conflict, where the majority, 75% of the cases have been prosecuted in absentia. And we're talking about it in the report as well. We have issues that kind of relate to the standards of fair trial in relation to also Ukraine's obligation under the European Convention on Human Rights. And this is something that is a very real threat to Ukraine as well, because if there are ongoing procedural violation in relation to the prosecutions of some individuals, they can later on bring the case against Ukraine to the European Court of Human Rights. And, we've seen, like, in many instances in the post-conflict sort of situations with especially like Balkans, and that was sort of a persistent issue at the ECHR, and they sort of, the jurisprudence is there. We know what we need to improve, but for some reason it's not getting prioritized by the policymakers at this point. So we're hoping that this report would be a good advocacy boost to them as well. If you want me to go into the details of the in absentia and what exactly is not sort of what the exact issues are, I can also do that.
Yeah, go for it. I'm wondering whether you really see these trials as actually fair. Do they have the right safeguards in place for those who are being put on trial?
No, that's we sort of, quite a while ago, we've identified the major challenges that relate to the notification of the suspect or the accused, to how the accused is getting notified. And it's one of the standards that the ECHR jurisprudence is very clear on, because we also had a precedent of MH17 trial where the joint investigative team used all the necessary and accessible means to notify the suspects, whereas in Ukraine, sort of the main ways and the practices to publish the notification of suspicion on some state public like newspaper, which also is a printed version. It doesn't even have the digital sort of version of it. And then they also publish it in Ukrainian on the website of the Prosecutor General, who never actually reads it. And then I think that's pretty much it. I know that there's some prosecutors who are more sort of, they've been doing it for a while, and they've been monitoring and following the MH17 trial, and they sort of more up to date with the standards, so to speak, the international standards, they can be more creative, but it's not sort of a standard that is set in the legislation, and it's not a standard practice either. Then we have the issue with the retrial. There is no provision that would guarantee a retrial to a person as well. And this is one of the key issues as well. And generally, the in absentia procedure is mostly used to actually give way to the investigations, like give way to show that Ukraine is prosecuting, but it's like an illusion in a way, because in reality, the in absentia prosecutions means that nobody is getting prosecuted because they're not physically in the courtroom, and because there is no opportunity to cross-examine them, to establish their side of the story, and then for the judge to actually make a call based on both sides.
I wanted to say, when we talk about absentia and the thing you talk about, I know this from the Dutch system, where in absentia trials are allowed. They are only allowed under the European Court of Human Rights if, when a person does show up in the country or is arrested or transferred to that country, and there has been an in absentia trial, that you have the right to a retrial to that first trial. And so what I understand from you is that Ukraine does not have that safeguard. We were also wondering about the fair trial rights, apart from the right safeguard, and the difficulty with getting defense, because we're already seeing in the cases where there are actually defendants that show up, it seems to be difficult to find Ukrainian defense attorneys willing to take on Russian clients. How does that work in absentia trials? Is there a system for the defense lawyers, and how do you tackle those problems?
So by Ukrainian law, everybody has a right to defense, which is a good standard in a way. But this defense is normally provided by the public defense service, or free legal aid, as we call it here. And those are the lawyers who are they're state lawyers, and they cooperate with the state. And normally what happens is they represent the defendant in absentia. Obviously, is already very limited because they don't usually have access to these people. So it's very difficult to develop, the defense position on that, let alone to, also cross-examine and, all what needs to happen in court as well. Usually, the majority of the public defense lawyers, it's a tick box exercise for them, because they know that they need to do it, or they must do it. They're obliged because they're working for the state in a sense. And so they just present in the case, they sign the documents, but essentially there is no substance to that work. Very often it's either very formal approach, or they tend to agree with the position of the prosecution, and they don't really develop any of the substance of their own. We do have exceptions to that, and we know of such cases where, despite this obstacles and difficulties, the public defense lawyers actually try to do their job as well as possible. But again, other factors then come into play, such as public stigma, and also because you are defending the war criminals and stuff like that, and persecution. And also, if this is, for example, a public case, that was a real example, a public case where a public defense lawyer is doing a good job and actually is successful in undermining the prosecution case, then there is also a danger of him being persecuted by the state itself. There is no mechanism in place to ensure public defense lawyers actually, even if they are doing their job well, they're actually protected, and they can do it without any danger of being stigmatized or punished by the state for doing basically their job.
When you say that they're persecuted by the state for doing a good job, how should I then imagine that? If they do too good a job, they get struck off the public defense record, or there are actually charges for kind of defending them so well that you're almost collaborating? How should I see that?
It can be any shape or form. It can be pressure on their family members. It can be pressure on themselves. It can be, we had instances before where public defense lawyers who were defending Russians, for example, there was a case before the invasion of Yefremov and Alexandrov, and there were two soldiers captured by the Ukrainians, the first two soldiers, and their lawyer was murdered under very suspicious circumstances, and nobody was able to establish. I mean, they say that they found the, but again, nobody's going to ever know the truth about that one. There are different versions of the events there, but the fact is that he ended up being dead. And also, we know of other lawyers who, for example, defended some what we call separatists. Again, it's pre-invasion time, but they were private lawyers. But again, they were stigmatized so badly, like nobody wanted to sit next to them. So the aura that was created around them, like the public shaming and in the press and in public forum. So it's difficult.
Another area that I've found my eyebrows been raised when I've been reading about is the cases that have been taken against people for collaboration or treason in some form, which I do understand this is a nation at war, and I do understand that examples need to be shown, but it has a funny, because my concern is, should not more of the resources go into war crimes and so on? So is it important to do these kinds of trials? Are they being done well?
Well, not at all. Actually, we had this discussion with my colleague today, who are, working really sort of specifically on this issue in another NGO, and they've been analyzing the sentences, the verdicts in these cases, to which they managed to gain access. And the trends are really worrying. But another thing for these cases is that, and this is like a strategic, substantive issue that we need to resolve, is the fact that you're absolutely right that they overburden the system, which is already overburdened to the extent that is hard to imagine. But with these cases, Ukrainian legal system sort of shows or demonstrates how effective it is. Because it's very easy to find these cases. You just slap that charge to anybody who lives in the occupied territory or the territory that doesn't, not under Ukraine's control. And yeah, you prosecute those people in absentia, and they're like hot pies, where you can just can have one case after another, like a conveyor belt. And, at the end, when you have to report how many cases you've prosecuted, or you've investigated, you can show a good number of those cases, and they're easy. There's no so much international or like public scrutiny, and they're very easy to explain to the population why these people are being prosecuted, because, this social sort of perception that, if you didn't run, if you stayed under the occupation, then automatically you support the aggressor and whoever in the separatist regime or whatever. So it's very worrying. But one of the latest cases that really made us do something radical about it as civil society, and it's still ongoing. There are two women, I think one from Zaporizhia Oblast and another one, I can't remember, Kharkiv maybe, but basically they are being prosecuted right now for collaboration because they remained in the occupied territories to help the sort of old and disabled people, to provide medical support to them. So basically bring them medicine, buy medicine, bring them medicine, food and stuff like that. And we see many cases of like teachers or just really not essential to the functioning of the sort of the population, general population, but nothing to do with sort of political side of things, people being prosecuted for that. And it's just, it's a very clear violation of IHL. And I think one light at the end of the tunnel that we've managed to see was that I think the OPG are getting clued in into the issue, and they are essentially right now trying to explain to the regional offices the standards and in what cases it is possible to prosecute collaboration and treason, and what cases they shouldn't be even open the investigation into the actions and so on and so forth. So I think they're trying to process it and correct the cause, but we're still kind of far from, the ideal.
When we're talking about the OPG, or the Office of the Prosecutor General, and thorny issues, we also see occasionally reports of Ukrainian forces breaking the laws of war. Just recently we saw a New York Times article detailing allegations that a Ukrainian unit shot captive Russian POWs. Now, Ukraine has promised to crack down also on its own forces for war crimes. Are we seeing cases like that make it into Ukrainian courts?
The short answer is no. And I don't think that, I'm not saying that there haven't been any attempts from some of the judges, especially the ones who are sort of work in regional courts close to the front lines. They talked about cases like this, but they're very, very, very difficult to prosecute, because apart from the lack of the state support in general, we also have a situation where, for example, military comrades, for example, or of that person who is being prosecuted, or they're like fellow soldiers, or those who just generally, their position is that, okay, we are defending Ukraine, we are defending all of you, you have no right to prosecute us. I mean, we are the ones calling the shots, and you have no right to say anything against it. And so they can show up pretty much in the court building or court premises and threaten with guns and to judges. And that's another issue with courts, that, and it's like a chain reaction, because we don't have enough resources to ensure a good security and safety of the people and judges and so on. So
sounds like a very unsafe situation. I mean, has that actually happened, that judges have been threatened?
That was a real story, yeah.
Maybe linked to that, I mean, the impression from the outside is that there's a huge amount of resource going in to support the Ukrainian justice sector. Everybody and their uncles that we know is involved in one way or another. Also with the idea of, like, here's the test case, here's to show how it can be done. If we could do it for Ukraine, it could be done for so many other places. So how's coordination going as far as you're concerned? Do you think it's helping?
I didn't see, the coordination was very bad at the beginning. And then I thought, okay, but, we're human beings, we're intelligent beings. Hopefully see the problems, and we will try and correct them and move towards sort of more effective and efficient coordination. But unfortunately, I don't see any sort of external moves towards fixing this problem of coordination. I think the general approach, and this is also a very serious cause for concern, is that, or reason for concern, because many states sort of feel obliged to do something. Their approach is just to throw something at Ukraine and then report to whoever they need to report, or demonstrate publicly that they've done something, without kind of evaluating and analyzing, okay, what are the obstacles that need to be overcome on the ground in order for the beneficiary, or the intended beneficiary of the resources, to actually get the resources and then translate them into the actual results. Because we have all these trainings, we have all these sort of, the equipment is being bought, software is being bought, but none of it actually, or like DNA labs being donated, but nobody kind of thinks about the fact that we cannot use these things, because from the legislation point of view, there is no authorization for its use, or trainings they don't really reflect the need of the investigators or prosecutors in a way that it's okay to teach the international standards, but then how do you actually apply them in the realities of Ukrainian legal system, with the legislative limitations, or the, the specifics that need to be also taken into consideration. And also the issue is that for the Ukrainian prosecutors or the investigators, they don't have time to sort of try and communicate it to the experts. That don't feel like they are in a position to say, thanks, but we can't use that because we don't want to come across as ungrateful. We don't want to come across as we don't appreciate the assistance. We do, but at the same time, it's like, okay, but we don't know what to do with it. We can't use it. And then essentially on the ground, the situation is not really being helped too much, or it doesn't really change.
If you're a Ukrainian war crimes prosecutor, how many trainings do you think they have had by now on international standards from different organizations? Or how many trainings do you get offered?
It's a good question. I think some of them had very, very, very many trainings, and some of them didn't have any at all. We had a situation, for example, in Sumy region, and this is like near the front line, very close to the border, like it's bordering with Russia, essentially. And that was about a year ago when our colleagues went to speak with the investigators and prosecutors there and to see what help they needed. And they said, like, we're not getting anything, like at all. No, thank you so much that you came. They were like, my colleagues were the first people who turned up there and asked them, do you need anything? Do you need any kind of support? Whereas at the same time, we see that people from like central offices constantly come and go, The Hague, Warsaw, France, like you name it, all this sort of, we call it professional tourism.
Yeah, we see a lot of them in The Hague. And of course, it's great that they get all this training and support. But the question, of course, is indeed all those nice international people sent to train people, they usually don't go to the front lines or places that are still insecure because, insurance and hostile environment training and all these things, security risks. But those are also where these cases are actually being prosecuted. So I was interested in seeing how much help they got.
The other thing that we've also actually risked discovering is that once the technical assistance is dispersed, so to speak, nobody's asking for the feedback, the results, how effective it's been, to what use has it been put. Do you see any problems? Do you not see? Like there's literally no report. So I think it's the issue for the states who are providing technical assistance to also actually have some kind of a mechanism whereby they, control systems in place, or I don't know, that's sort of the monitoring and evaluation system for analyzing how effective the assistance has been.
What about the different moves that we see also going on towards trying to get some universal jurisdiction cases going? Just as we're recording this sometime in the middle of July, I've seen that Clooney Foundation, together with another organisation, is presenting some material in Geneva at the Human Rights Council. I know that Stefan has been especially doing stuff on Argentina there. I mean, is there a good coordination as far as you're concerned with all of these different initiatives for different other places to carry out trials connected to the conflict in Ukraine?
Well, I know for the EU states, we have a EU Genocide Network, and they're trying to sort of provide some kind of coordination platform for these states. But again, I think there's a lot of sort of margin of appreciation, or like the discretion that the states have in terms of the deciding on what cases they're willing and have the capacity to prosecute. On the other hand, in terms of all these other states, it depends, because we had some conversations internally with the NGOs specifically focusing on UJ, and for example, their feedback of some of these states is not very positive, because while they do have the provisions in their criminal codes or criminal legislation for the use of universal jurisdiction, generally speaking, their practice is very limited. And the standards are also vary significantly from one state to another, and very sort of difficult to identify those states who would have genuine interest and capacity to prosecute Ukrainian cases, or cases that, Ukraine is concerned about, without having that passive or active personality link where, the victim or the perpetrator is not the national of that particular state. France, for instance, was very honest, as far as I'm concerned, from the get-go, when they said, like, okay, so we're only having individual investigations and the only concern French victims or French perpetrators, and so your scope is clear from the beginning. With Germany, it's been the opposite, because they have a very broad powers, and there's also broad discretion, and while they seem to be the most flexible and the most, in a way, advanced in terms of who can bring the case under the UJ, they would still pretty much base it on their internal decision-making process, which is, do we have the resources? Do we have the prospects of prosecuting or executing the arrest warrants? Do we have enough witnesses? And going through that analysis, you kind of realize that it's very unlikely that the individual cases will be prosecuted in Germany. And also another thing is that if we are talking about UJ as a mechanism for complementarity, it's very difficult to explain to states why we are coming to them and asking them to open a case under the principle of universal jurisdiction when Ukraine is already investigating. But Ukraine is investigating all of these cases, because it's by our law, we cannot not open the investigation in any kind of incident or episode. And so then you need to go to the state and say, like, look, okay, yeah, fine, but we don't have crimes against humanity, we don't have command response. And so you start this arguing back and forth and trying to convince them. And it's also like a time and resource consuming process, which has very little prospect of being successful. So yeah, it's not a sure thing, definitely.
If we zoom out and go from local jurisdiction and universal jurisdiction to international courts and tribunals, we have cases at both the ICC and the ICJ, and we have the move towards an aggression tribunal being set up. We now see some progress where it seems like they're doing something based around the Council of Europe. How do you think those developments are going towards an aggression tribunal?
I know that there was supposed to be another meeting of the core group in Bucharest a couple of weeks ago, I think. So I don't know what was the latest, but for some time it had been deadlocked. I mean, the discussions on the tribunal and the modalities, because they were stuck on which definition to use for the crime of aggression. And I think it's a very sort of pertinent issue, because on the face of it, it doesn't seem to be that complicated. Just use the international or Rome Statute definition. But I think it's also a politicized question, because there is no appetite among definitely the G7 members to establish an international tribunal on the crime of aggression. So they actually pushing for a hybrid. And if we're talking about a hybrid mechanism, that means that the mechanism for overcoming personal immunities of the top political leadership and military leadership of the Russian Federation cannot be overcome. And that makes the entire project very moot, because then what's the point in creating something that will not be. But I guess from the political perspective, they just the international community just happy to set up something which they can say, okay, but we've done it, we've established a mechanism, so just be happy with what we give you.
But Nadia, what are you lobbying for? Because what I hear, what you're saying there seems very much the position I can remember when I first discussed this with you a couple of years ago. Is it still that you think that there should be a kind of a broader, more useful, in your view, more useful tribunal that can tackle a lot of different crimes for Ukraine, with Ukraine internationalized to some degree?
Yes, that's exactly what we still lobbying for. And I think the current sort of deadlock can be leveraged exactly for putting in place a hybrid tribunal, but which would have the jurisdiction or the mandate not limited to just the crime of aggression, but actually include all core crimes. And I think this is important for two reasons, or actually more probably. But so one of them is going to be a useful mechanism. It's going to be created and it's going to exist and politically is going to make sense. Second, I think is going to actually help build the capacity of Ukrainian authorities and actually push for the necessary reforms from the perspective of the legislation that will need to be required to actually make this tribunal operational. But also from the financial perspective, at least it will be a mechanism where you can see where the money or all the technical assistance will be going to and what effect it will be taking. Whichever way you look at it, I think it's a win-win-win for everybody. So I don't really see the problem with that. And I think for our authorities, it could also be a positive step in kickstarting, developing a justice system which is geared towards victims, it's geared towards international standards, and it's geared towards effective use of the resources.
Nadia, thank you for that summary. I'm, as you know, based in Vilnius, and I believe that here is going to be where the next core group meeting is. So if I can sneak in and find out what's going on, I'll let everybody know sometime in September. But otherwise, I do suspect that this inching forward or centimetering forward, whichever way you want to put it, is likely to be the way through. As you know, at the end of the podcast, we always ask a few different questions. And the first one is there something that we should have asked you that we forgot to, or that you would like to say anyway, that's been burning, that you really want to get out in this podcast?
Yeah, I just wanted to thank you both for still not giving up, not giving into the Ukraine fatigue, so to speak, because, there are very many difficult conflict situations around the world, and you guys are still keeping your attention on Ukraine, for which I'm very, very grateful indeed.
Oh, thank you so much. I know, like us, that you are a law geek, and so our next question should be maybe easy for you. Do you have a favorite court case or a case that you like to talk about, or that you see as an example, or something that inspired you to become a lawyer, or something that was just very, very funny that you had to follow?
Honestly, I mean, that's like putting me on the spot. I think Tadic case is very good because it really made that leap in defining the command responsibility and the sort of joint criminal enterprise, and just giving that complete sort of completely different look at what international justice is and how it should be kind of like prosecuted in procedural terms, so to speak.
Now you're totally in my wheelhouse, but for everybody who isn't super into the ICTY and Balkans trial, the Tadic case was the first trial of the International Criminal Tribunal for the former Yugoslavia, where they essentially had to legislate all the basics. What exactly is an armed conflict? How do we rule on this? What is command responsibility? How does that work? And all these cases are still cited in the cases before the ICTY and also in national courts dealing with war crimes today.
Exactly. Nadia, Tadic comes up regularly. And of course, we put you on the spot because that's the idea. You're just meant to say the first thing that comes to the top of your head. And that's the same with the last question. What have you been reading or listening to or watching that you would like to share? It can be to do with work, or it can be to do with not work. And we know that Ukraine, as we're speaking to you, is again not in a very good shape. Again, heavy bombardment. So I have no idea whether you have even any time to watch, listen, or read to anything. But yeah, do share if there's anything that you can for the audience.
Yeah, the latest film that I watched actually was just before the missile attack, was Ungentlemanly Warfare, something. I can't remember the entire title, but it's one of the latest Guy Ritchie films, and it was based on true events from Second World War, how the spies unauthorized operated to make Great Britain win the war against the Germans.
the Ministry of Ungentlemanly Warfare. I've just looked it up, and the whole beginnings of dirty tricks during the war he definitely enjoys exploring.
Exactly. Very smart, very clever movie. And then the book that I'm reading right now, I'm trying to get into the statecraft issues, because while the war is ongoing and it's ruining a lot of things, I think there are opportunities for actually looking towards something what we would like the new Ukraine to be like. To that end, I started reading Plato's Republic.
Ooh.
Yeah, very interesting.
And what do you think, apart from very interesting? Would you recommend it?
Yes, but you can't, like, for me, it's very difficult to read it for more than half an hour, because you really need to process it and put it through your system to actually, understand and see what is it that he's talking about, why it's important. For example, there's a lot on justice and what the definition of justice and the essential meaning of justice. And this is very interesting to me as well, of course.
Maybe when you've processed it all in a year or so, we'll come back to you for another digestion.
We'll have a separate podcast on Plato's Republic.
We can invite you on our book club, but then I would have to read Plato's Republic. So maybe I'm going to walk back from this idea. But I'm always complaining when we have to read the classics. Culture Philistine that I am, I like to do a lot of escapism reads.
Yeah, that too. But I can't say it on podcast.
Well, we'll take this offline, but I'm very curious what the escapism is. But I have already confessed to many trashy escapism books on this podcast, so I have no shame anymore in doing that. But thank you so much for taking this time out in a very difficult and again heated up period in Ukraine. But we really appreciate that you wanted to talk us through all this. Also, reading your wonderful reports and seeing such detailed analysis of what the Ukraine legal system is doing is really interesting, following that kind of thing real time. So thank you so much.
No, thank you so much for, giving the opportunity to talk about it. No, it wasn't easy, but thank you for finding the time and the resources to do that.
Thank you.
This was Asymmetrical Haircuts, your international justice podcast. Created and presented by Janet Anderson and Stephanie van den Berg. Music is by audionautics.com, and you can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.